Yes, Your Honor.
It's alleged, Mr. Hahn, that at Fayette Township on February the 9th of 2024, you tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor. Maximum penalty 6 months in jail, $1,000 fine, theft offense. Do you understand the charge?
Yes, Your Honor.
Do you understand the rights you have?
Yes, Your Honor.
How do you plead to this charge?
Not guilty.
You want a lawyer appointed to represent you?
Yes, please.
Do you have a job?
No, I'm in college right now.
Okay. I'll appoint Mr. Thompson to represent you. We'll get him in the courtroom. He is here today. We need Mr. Thompson in the courtroom. All right, guilty plea is entered. Mr. Thompson, this is Christopher Hahn. It's a shoplifting charge from Walmart. Entering a not guilty plea for him. He can sign a signature bond of $1,500. About April the 8th is a hearing date. Is that good?
Yes.
April
That's
the
a
8th.
Monday, right?
That is a Monday. April 8th, Monday. Pre-trial. Then he can sign a $1,500 signature bond.
It's 1,500.
You just need to sign.
Okay. Right there. Yes. What's your phone number?
562
562.
380 380 7664.
Okay, sign this. And then we're good. Thank you.
You're welcome.
State of Ohio versus Heidi R. Taylor, case number CRB 2485. Heidi R. Taylor.
Saturday.
1 o'clock.
Yes.
Heidi Taylor.
7:30 speaker, please.
Yes.
Thank you.
Heidi Taylor was served
Thank you.
February 21st. Personally, with a copy of the complaint and summons, has not appeared today, so there'll be a warrant issued for failure to appear.
State of Ohio versus Bailey Key, case number TRC 24521, A and B.
And ma'am, are you Bailey Key?
Yes, Your Honor.
Ms. Key, it's alleged that March the 16th at 1:31 a.m. in Fayette Township, you were operating a vehicle while you were under the influence of alcohol. It's alleged that you took a breath test and tested 10 on the breath test, and that this would be your first time you've been charged with this offense. On a first offense, the maximum is 6 months in jail, a $1,075 fine, and a 3-year license suspension. There is a minimum penalty, which means I can't go below this penalty I'm about to tell you if you're convicted. The minimum is 3 days in a treatment program, $375 fine, and a 6-month license suspension. The state's alleged you took a breath test and tested 10. The per se level under Ohio law is 8. So what that means is there's a presumption of impairment in Ohio. You take a breath test and test above an 8, but to get the presumption, the state has to show compliance with the rules for giving the test. There's rules about calibration of the machine and how they give the test. So they have to show compliance with that before a presumption attaches to the test. You understand those things?
Yes.
You have another charge, driving outside your lane. That's a minor misdemeanor. Maximum penalty is a $150 fine. So you've got 2 charges. Do you understand those 2 charges?
Yes, Your Honor.
Do you understand the rights you have as a defendant?
Yes, Your Honor.
Any questions before you enter a plea?
No,
What plea do you wish to enter?
not guilty.
Do you wish to have a lawyer appointed to represent you?
I can hire one.
Okay, I'm looking at probably April 12th is your next hearing. Can you have a lawyer hired by then? Okay, April the 12th. So that's a little over 3 weeks away. April 12th will be your next hearing, unless your lawyer tells you they've made arrangements for a different date. Be here April 12th at 10 a.m. Coming down, you will hire a lawyer. And she can sign a signature bond and letting you sign what's called a recognizance bond, which means you're guaranteeing your own appearance by signing this piece of paper that says, I promise to come to court when I'm ordered to, or I'll pay a $1,500 penalty. So as long as you come, you don't have to post any money. You get a warrant too if you don't show up. So that's the worst part. Just show up, you won't get a warrant, and you don't have to post any money. Any questions, ma'am?
No, thank you.
Okay, that's all.
State of Ohio versus Howard Thornton, case number TRC 24530, A, B, and C.
Are you Howard C. Thornton?
Yes, sir.
Mr. Thornton, it's alleged that on March the 13th at 1:51 p.m. in Mason Township, you were operating a vehicle while you were under the influence of alcohol or drugs or a combination of those things. And it's alleged to be your fourth offense lifetime, but in the last 10 years, it looks like it would be perhaps the third offense, depending on if there was one in 2014. So it could be a third offense. On a third offense, sure I'm telling you correctly. On a third offense, the maximum penalty is 1 year in jail, $2,750 fine, a 10-year license suspension. The vehicle can be forfeited on a third offense if it was titled to you. If it's not titled to you, then it can't be forfeited. The minimum penalty on a third offense is 30 days in jail, $850 fine, and a 2-year license suspension. Do you understand the charge? You're also charged with driving with a suspended license. That's the section you're charged with is an unclassified misdemeanor. Maximum penalty is 500 hours of community service and a $1,000 fine. You're charged with failure to control your vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine. So those are the three charges. OVI, driving under suspension, and failure to control. Do you understand those charges?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you wish to plead?
Not guilty?
Do you wish to have a lawyer appointed?
Yes, sir.
Are you working?
No, I'm not.
You have no income?
No, sir.
I'll appoint Mr. Steyer. All right, Mr. Steyer, this is Howard Thornton, and there's a question. It could be a second or a third. I arraigned him as if it's a third because there was a prior in 2014, so that's something you want to take a look at.
I'll take a look at that, Your Honor.
Since he's appeared today, I'm going to let him sign a signature bond of $3,000 OR.
You can sign your name right here. Yeah.
I'm looking at April the 8th or later for pre-trials.
Are Monday versus Friday better for you? Does it matter?
Excuse me?
Does Monday or Friday matter to you?
No.
Okay. I'm available April 8th.
Okay, April the 8th will be the next
So
hearing.
write that on here.
Where'd it go?
Right here. He took it.
Oh, I didn't sign it last week.
Oh,
I'm sorry.
April the 8th will be the pretrial.
just a second, Your Honor. We're having trouble with the bond form.
April 8th?
April
the
8th.
8th, 10 o'clock will be the next hearing
Okay.
for a pretrial.
All right, just wait for me in the lobby, sir. I'll be at the talking to sir, okay? Thank you.
Okay, that's all, sir.
Thank you, sir.
You're welcome.
State of Ohio versus Michael Miller, case number TRD 24-529, A, B, and C. Michael Miller.
Michael Miller has been called for, has not appeared, was cited to be in court today at 9 a.m., has not appeared today. So, actually, I'm going to send this back to the OSP because the offenses for which Mr. Miller were cited were not jailable. Doesn't look like, you can check and make sure that's correct. Well, perhaps they were, he's had some prior convictions for driving under suspension, so this may be jailable now because of that. So I'll go ahead and issue a capias to the OSP since he failed to appear today.
State of Ohio versus Tony Walters, case number CRA 23-466, CRB 23-467, A and B, CRB 23-54. Tony Walters.
Okay, this was a case set for pretrial on March the 1st. It looks like Mr. Smith, Tyler Smith is your lawyer.
Yep.
I don't think he's on the docket. Do you have an explanation for not being here on March 1st?
Well, I called here and I called his office, told him I was out of town and I ain't got licensed to come back from Florida and I was with my daughter and grandkids.
Okay, well, this trumps visiting your grandkids, so I'm going to place you in custody. I'll contact Mr. Smith and see if we can get him here. You're ordered into custody this time.
State of Ohio versus James R. Stover, case numbers CRA 19694, excuse me, TRC 192630, A and B.
May I approach, Your Honor?
Yes. Okay, it's a good report. It looks like you went into treatment in July of 23.
Yes, Your Honor.
This is a OVI conviction from 2019.
Your Honor, when this warrant was issued, I believe Mr. Stover was incarcerated. He's also in Judge Finley's reentry court.
Okay.
He's
He had
compliant.
a review hearing in November of 21 is when this warrant got issued, so he was in prison at that time?
Yes, sir.
Okay, he still has community service and fines here to pay.
He's going to pay some on his fines today.
Okay, how much are you gonna pay?
I could pay a substantial amount, $200.
Okay. So I'll withdraw the warrant. You're lucky you didn't get picked up because you had a warrant outstanding all this time.
Yes.
Since November of 21. I'll withdraw that warrant. I'll put you back on a schedule for review hearings. How often do you go to the reentry court?
Every 2 weeks, Your Honor.
Okay. What days of the week are those? Wednesdays?
It's on Thursday.
Thursday? Okay, so this shouldn't interfere with that.
What day works better for you?
My work schedule would be Monday.
Mondays work better for him, Your Honor.
April 29th is going to be your next hearing here. Just work on completing what you have left. I'm showing you owe 54 hours of community service, $725 in fines.
Yes, Your Honor.
See the clerk make your payment on your fine today and start working on the other stuff. And one thing I can let you know, and everyone else that's listening that this may concern, April the 12th and 13th is Fayette Township Cleanup Day, so we're going to give double credit for those days. So if you work both of those days, you'll get 4 days credit for doing 2 days, or if you do 1 day, you get 2 days credit. So
Thank you, Your Honor.
you're welcome. So April 29th is your next hearing. Once you get this finished, you can quit coming to these hearings.
Thank you,
Glad
sir.
you're in getting sober and clean.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Robert Gilbert, Your Honor, this is a pretrial. Case number CRB 23567, A to B. We'll have other arraignments later.
Okay, this is Mr. Holt's case.
You got a pre-trial, you need to be in the courtroom now, pre-trial.
All right, this is Mr. Holt's case. My notes were this was going to be dismissed if the costs were paid without an appearance.
Correct.
I'm not showing the cost.
He's not paid him. I don't have any information in your order.
He was at half, getting reports from them. How do you want to proceed on this?
If I could have a chance to get a hold of him, he's appeared for everything else, Your Honor.
Did you ask for continuance?
Yes, Your Honor.
Do you have a preference as to a date? Would the state agreeable to the continuance?
Yes, Your Honor, as long as Mr. Holt will fill out one of these continuances.
We're happy to. Would April 5th work, Your Honor?
Yes. April the 5th at defendant's request will be the next hearing, 10 o'clock. He still doesn't have to appear as long as he pays the court costs.
Your Honor, we're ready to go to Lawrence County Jail.
Okay, we're going to go to the jail for some hearings now.
State of Ohio versus Patrick S. Jones at the Lawrence County Jail, case number TRC 19378, A, B, and C.
Patrick Jones. I think he had failed to appear here for a review hearing, and Mr.
I gotta sign it.
Sowers picked him up. It's actually been, it was marked as a sentencing hearing because he had to bond up. Through Mr. Sowers. The sentencing hearing was January 22nd. Obviously, he started services the day after he was supposed to be in court. I'm assuming that you all didn't know you had a court hearing?
No, I
think
found
you would
out.
probably say you gotta go to court, right?
Yeah, Friday, I noticed that he was on the docket, and that's when I talked to his therapist about talking to him to get him to come and turn himself in, and that's what the original deal was going to be for today, but then he got picked up on Friday, I'm assuming.
Okay, Mr. Jones, what do you have to say about this? Can you hear me?
Yes, sir. I messed up back in January and relapsed and went and got help from ROG again. And I talked to Heather last Friday about coming in and getting it taken care of today, but I got picked up before.
Okay, so you got to spend the weekend in jail. I'm showing you still have 7 days of community service and some fines to pay too.
Okay.
All right, so you're going to continue with your treatment?
Yes, sir.
I'll send you to time served for not coming to your hearing. I'm going to give you a new hearing date. Make it 1 month out, April the 19th. So April 19th will be your next hearing. I'll make it a sentencing hearing at 10 o'clock. Keep working on your sobriety and your fines and court costs and community service.
Okay.
So you get out of jail today.
Thank you, Your Honor.
All right, thanks, sir.
You're welcome.
We'll finish it, Your Honor.
Okay.
State of Ohio versus Hallie A. Pack, case number TRC 1648 A and B.
Mr. Holt's case, so it's a pretrial today.
What is that? Approach, Your Honor.
Yes. In this case, there is a problem with the evidence in that Ms. Pack took what's called a portable breath test, and this showed only a 0.3 test score, which is well below the per se level. And then when she got into the post, she took a Intoxilizer 8000 test that showed a lot higher test score, so one or the other was wrong. So, and based on the performance also in field sobriety not being bad, the state's willing to let her plead to a reckless operation. She also already went to on her own, went to the 3-day driver intervention program and completed that. So I'm okay with that under this factual scenario.
Thank you, Your Honor.
It's going to be amended from OEI to a reckless operation, 451120.
There's a speed as well, Your Honor. We would enter plead guilty to both of those.
And her speed was high, so. Anything you wish to say, Ms. Pack, before I sentence you?
No, thank you, Your Honor.
Okay. On the reckless operation, I'll give you a $150 fine, each of the max, and I'm doing that mostly because of the speed. 85 miles an hour is not reasonable speed. So I'm going to give you the max on both. So you'll get a $150 fine, court costs on the reckless operation, there is no jail time or anything. Then on the speed offense, I'll give you a $150 fine on that also. No court costs on that, but only assess one court cost per case. Can you pay the fines and costs today?
Yes.
Oh, well, I see a problem here. Proof of financial responsibility, do we have that?
Oh, she has produced that before. Do you have your car insurance with you?
Not with me now.
Could you
I'm
zoom
not
in?
sure.
It has on my phone, yes, I have it on my phone.
Yeah, if you pull it up on your phone and show it to the clerk. Has to be the one on the date of your pre-order. So it have to be the year before. May I approach the clerk, Your Honor?
Let me look at it.
October 3rd.
Okay. You can show proof, you did have proof of insurance.
Thank you.
What are you looking at?
What was the ORC,
45-11-19.
was it M1 versus
Yes. And show proof of insurance. And it's $150 fine on both. Does she need time, do you need time to pay or can you pay it today?
I can pay today.
Okay, no probation. See the clerk and pay it and you'll be completed.
Thank you very much.
You're welcome.
Thank you.
State of Ohio versus Matthew Russell. Case number CRB 17979A and B, PRD 173254.
Mr. Holt's case. How do you wish to proceed in this?
I'm sorry.
He's talking to state.
Oh, is this a 17 case?
17 case. It looks like he had failed to appear initially and didn't get arrested till February of '24.
Okay, so it's still an open case. What's the charge, Your Honor? I apologize for not having the file. That was a long time ago.
It was a red light, running a red light, and possession of drug paraphernalia.
Yes, Your Honor. I believe the officer is no longer working in Lawrence County either. I believe it's mischarged because it was a marijuana paraphernalia, which the M4, I don't think was even charged correctly, but we'd be willing to pay court costs if the state would be willing to dismiss.
We're not opposed to that, Your Honor.
You can do that today.
How much is it?
Typically, well, you have a warrant, so maybe 150.
Does that be the whole amount?
Yeah. I guess this minute.
I can. I don't have cash, but I can go get cash.
Yes, he can today. He has to go to 18.
Okay, yeah, we're here till 4.
Okay.
Thank you.
Thank you, Your Honor.
Be dismissed on payment of court costs.
State of Ohio versus Astrojan Bosmanoff, case number CRB 24131.
And sir, you, Mr. Bosmanoff?
Sorry, sir, I do not know English.
All right. Is there anyone here that can translate for you?
Uzbek.
Okay, I see, I think someone came with you.
Might be a co-defendant, right?
What language do you speak, sir?
Uzbek и Russian.
Russian?
Yes.
Well, we can get a translator through the Ohio Supreme Court, and we might even be able to get that today. If you want to wait, I can try to get a translator over the phone.
Uzbeki Russian?
Russian.
Is it just Russian or Uzbeki Russian? Is that different?
Yes. Uzbek и Russian.
Okay.
Translation. Yes.
It is Russian?
Yes.
Okay. Yeah, I guess we'll need to have a,
Just have a seat, we'll have the clerk try to, we did this once before, got a translator that appeared by teleconference. We'll recall you, sir. Just have a seat.
State of Ohio versus Marguda John Morbakoff, case number CRB 24136.
Need Russian translator.
Question, when would you like to have it ready?
Whenever you can get
Okay,
it.
I'll put them on.
Good morning, sir.
All right, and sir, do you speak English?
Little bit, sorry.
Okay.
Me too.
You are charged with a theft offense.
This is on joint? Yep.
It's alleged that on Saturday, March the 16th, you tried to take property from Walmart here in Lawrence County. That's a theft charge. Do you understand the charge?
Yeah.
Maximum penalty is 6 months in jail, $1,000 fine. That's the most that can happen. That doesn't mean that's what has to happen. That's the most you can get is 6 months in jail, $1,000 fine.
Okay.
You have a right to remain silent. You have a right to have an attorney, a lawyer appointed to represent you.
Yep.
Do you have a job?
Yep.
What do you do?
It's pick up job.
You drive things, and you live up around Cleveland?
Yeah.
Loveland, Cincinnati, Your Honor.
Oh, Cincinnati, okay. Do you want a lawyer appointed to represent you?
I don't know. It's a little bit speak, sorry. I understand.
Do you want a lawyer? You want someone to help you with this?
Yeah.
Okay, I'm going to appoint Mr. Smith. He speaks some Russian. Maybe you can help with the other cases. They came in together. This gentleman seems to speak more English than the previous gentleman. Okay, so I'm going to appoint you, Mr. Smith. Why don't you take the file, talk to him. No, let's try to do something today.
Yes, yes.
He's from out of town. Let's recall it later in the docket. That's it.
State of Ohio versus Casey A. Burton, case number CRB 24-129.
Ma'am, are you Casey A. Burton?
I am.
Ms. Burton, it's alleged that on March the 16th of this year in Fayette Township, you tried to defraud Walmart property without their consent. That's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge? Yes?
Yeah.
Do you understand your rights?
Yes.
How do you plead to this charge?
If I say no contest, can I give a statement?
Yeah, so let me explain to you what no contest means. No contest means I don't want to fight this charge. I'm not admitting that I did it, but I'm not denying it either. And if the state has sufficient evidence to prove my guilt, I agree I can be found guilty without a trial and a lawyer.
Yes, sir.
Is that what you want to do?
I believe so, yes.
Okay. I'll accept your no contest plea. Do you have anything other than the affidavit, Mr. Beal? All I have is the affidavit.
The narrative may actually be the same as the affidavit. And it appears to be. So I don't have anything else other than that.
Okay, I'm just going to read the affidavit into the record, and then if you want to make a statement, you can. This is from Deputy Wes Parker. It says, March 16, 24, I was dispatched to Walmart for a theft. When I arrived, I walked into the loss prevention office. There was 2 females sitting on a bench, 3 Walmart employees. The loss prevention employee, Ms. Bagley, advised that they were still trying to add everything up. Asked the 2 females for their IDs, and they provided them. The 2 females were identified as Kelsey Gibson and Casey Burton, both from Kentucky. I gave them their Miranda rights and asked if they wanted to talk to me. Casey Burton began to tell me that it had been a long day and she has a habit of putting items in both of her hands when scanning. She must have mistakenly not scanned some items. Casey told me she takes full responsibility for what happened. Asked Mary Ann to show me the video, and I watched it. In the video, you can see Casey pick up items out of the buggy with items in each hand. She had an item in her right hand that looked to be scanned, then she placed that item into the bag, also with the item in her left hand without scanning yet. Asked Kelsey where she was when Casey was scanning the 2 buggy loads of items, and she told me she was right behind Casey. Asked Kelsey if she had seen Casey scan the pop that was in the bottom rack of the buggy due to that being one of the items that was not paid for, and she stated she did not. Kelsey also advised that she had realized that they did not pay for the pop when they were stopped. Walmart employees advised me Casey and Kelsey had not scanned or paid for 25 items that totaled a value of $142.06. Mary Ann provided me with the video as well as affidavits. They were transported to jail. They were respectful during my encounter with them. Okay, ma'am, is there anything you want to say about this?
I'm sorry. So this is our very, sorry, okay, I'm good, I can do this. Okay, so this was our first offense. Just some background information. I'm a professor at Rio Grande University, and I do substitute teaching for Boyd County Public Schools. And I have, like, May 20th, I got a job with the National Park Service to be an archaeologist in Page, Arizona, which is a dream of mine. And we were there at Walmart because we were getting groceries for the month, but also new household things for the apartment that we already kind of have set up for May. And we were already there for 3 hours, and we were trying to get somewhere by 9, and by the time we went to check out, it was 8:30. And so I was rushing and being careless and negligent. I was just kind of scanning things. My mind was a million different places, kind of going through what we needed else to get. And Kelsey was behind me, kind of organizing bags and things like that in the cart, but for the most part, like on the phone and stuff, not really paying attention. So when we were stopped, we weren't really sure what was going on. We get into the back room, and the only thing we could think of is like the pops that we didn't scan. Like, we were like, we must have not scanned those. And then when they showed the footage, I saw what I was doing, which I've caught myself doing before at a Kroger. Like, Kroger has like the weighted system, if that makes sense, with self-checkout, where if you put things without scanning, it alerts you. Because I've done it before, and I was like, oh, and I took the stuff back out and scanned it. But Walmart didn't have that. So I think that me rushing and being negligent in that way is kind of what caused some of the items were just, most of them were just groceries. We had the money, we paid $380. We were using a credit card, so it wasn't about that. I was just negligent, honestly. I just kind of was scanning too fast.
Well, you know, I'm not going to accept your no contest plea then, because what you're basically telling me is that you're not guilty, because theft is what lawyers would call a specific intent crime.
Okay.
Negligence is not the intent to steal. Negligence is not enough to be convicted of theft. If you accidentally take something, that's not stealing. That's being negligent. You know, theft means you actually intentionally take property that belongs to somebody else against their will. So, based on what you're telling me, you're not guilty of theft. So, I'm going to enter a not guilty plea.
Okay.
So, do you want, I mean, you are working, right?
Yes, sir.
Full-time?
Yes, sir. Well, it's 2 part-time jobs, but it adds up to full-time.
Do you want me to consider you for a court-appointed lawyer, or do you want to hire your own lawyer?
No, we tried yesterday, and like prices, we just can't do it, so.
Well, it's not based on the price, it's based on what your income is. So what kind,
Yeah.
I have to determine your gross annual income. So what do you make in a year? Do you file an income tax return?
Yes.
What do you think your gross income is for a year?
I'm going to say 38,000.
Okay, do you have dependents?
No, I have like a big car payment every month.
That doesn't matter.
It doesn't matter, okay.
It only matter, you know, what I have to look at is your gross income and your dependents. So
Okay.
if you have no dependents and you're making $38,000 a year, you make too much for me to appoint a lawyer for you. You'll have to hire one.
Okay.
So I'm going to enter a not guilty plea, and I'll give you time to get a lawyer. And this, you know, obviously this is important with your professional status. I would think this is not something that's going to look good.
Yeah.
If you got a conviction. So you need to get a lawyer and talk to them and see what your defenses are.
Sorry, I don't mean to, if today, because like I said, Lord's willing, we were planning on moving in May, and I know with this, there's a big hiccup there, obviously.
We'll be back before May, so.
So would it be like one more year if I hired a lawyer kind of thing?
Well, it takes what it takes. You know, I don't know how long it would take, but, you know, it's an important thing. So we'll set a pretrial. First of all, I got to find out how much time do you think you need to get a lawyer. I can set a hearing date pretty quickly, but if you need time to get the money together or hire a lawyer, I'm going to give you enough time to do that.
Okay.
What kind of time frame do you think you need?
Can I look at my mom? Because she'll be helping.
2 weeks, about 2 weeks, Casey.
2 weeks?
Okay, so that would be April 1st.
Okay.
And we'll set your next hearing for April 1st for a pretrial, and that's going to be at 10 a.m. I'm going to indicate you will hire a lawyer.
Okay.
And I'm going to since you showed up on your own, you already have a bond up there. You posted a bond.
Yes, sir. It was.
Okay, so your bond's continued that you posted.
Okay.
So be here April 1st unless your lawyer says they've made arrangements for a different date.
Okay.
Any questions? I'm entering a not guilty plea for you.
Okay.
Okay, that's all. Okay, you got a translator?
Yes.
Okay, let's recall the gentleman with the Russian. You'll need to take this. And is there someone there listening in? A translator?
Yes, my name is Marina, ID number 405674.
All right, thank you very much. We're starting an arraignment with the gentleman who needs a translator, so thank you very much.
State of Ohio versus Ashrajan Bosmanov, case number CRB 24131.
All right, so what we're going to do, we have a translator provided by the Ohio Supreme Court by telephone. So I'm going to say some things to you, she's going to translate, and then we'll go back and forth. Let's come close. I have the bail come closer so you can hear me. Mr. Bozanov is charged with theft. Can you tell him that, please?
Господин Базинов, вас обвиняют в краже.
Ну да.
Do you understand her, sir? Ask him if he understands you.
Не слышу. Алло. Повторите, пожалуйста.
Could you please repeat?
Ask him if he understands you, please.
Пожалуйста, вы понимаете переводчика?
Да. Да.
Yes. Yes.
It's alleged on March the 16th, he shoplifted at Walmart.
16 марта этого года вы совершали покупки в магазине Walmart.
Есть. Да.
Yes.
The maximum penalty is 6 months in jail, $1,000 fine.
Максимальное наказание за этот проступок 6 месяцев тюрьмы и $1000 штраф, $1000 штраф.
Нет, просто я как бы... Мы двое было, зашли туда, а я ничего не покупал и ничего не брал. Там, в магазине. Ну, туда и...
So he's entering a not guilty plea and asking if he enters not guilty.
Так вы признаете себя невиновным?
Ну, я не знаю, просто я ничего не покупал, там, не знаю.
Вы ничего не украли или... I'm so sorry, she said that I didn't take anything there.
So he wants to enter a not guilty plea?
Значит, вы признаете себя невиновным?
Ну, не знаю. Ну, я тоже был там, как бы. Ну,
Так вы признаете себя невиновным или вы не признаете себя
ну,
виновным?
хорошо, признаюсь. Ну, если надо заплатить штраф, да, буду заплатить.
Okay, I was there, but I plead guilty. And if I need to pay penalty, I will.
Okay, he said he pleads guilty to this charge?
Значит, вы признаете себя виновным по воровстве. Да?
Can you repeat that?
Вы признаете себя виновным в краже.
Ну, просто я тоже был там, мы вместе были. Просто я ничего не покупал оттуда, в магазине.
I was there with somebody else and I did not buy anything there. And he doesn't, this is the interpreter speaking, he doesn't answer the question, guilty or not guilty.
Okay, well, I'm going to tell him I'm entering a not guilty plea for him. Does he want a lawyer appointed?
Если вы признаете себя виновным или невиновным, скажите, вам нужен адвокат для защиты?
Ну, да, нужно было.
Yes.
Do you have income? Do you make money?
Работаете ли вы? Есть ли у вас доход?
Доход? Да.
Yes.
Yes? How much?
И какой у вас доход?
4000.
Я не слышу вас, повторите, пожалуйста.
4000.
I have income of $4,000.
$4,000.
How often? And what kind of time frame does he get $4,000?
И $4000. В какой промежуток времени вы получаете $4000?
За месяц.
A month.
Tell him he's not eligible for a court-appointed lawyer.
В этом случае мы не можем предоставить вам адвоката.
He makes too much money.
Вы делаете, у вас доход превышает тот уровень, когда вы могли предоставить вам адвоката.
А что делать?
And what should I do?
Hire a lawyer.
Нанять адвоката?
А самому найти?
I can do it myself. I should do it myself.
Hope not. I hope not, but you have the right to represent yourself, but it wouldn't be a wise thing since we're going to have a problem communicating. I'm going to enter a not guilty plea.
Вы можете сами себя представлять людей, или вы можете нанять адвоката, который будет вас представлять, если вы признаете себя невиновным.
You can tell him I'm entering a not guilty plea and setting his next hearing April the 12th, 10 a.m.
Значит, вы признаете себя невиновным, и следующее слушание назначено на 12 апреля.
Can we keep her on the line? I have the co-defendant. Thank you.
I'll tell her to talk with you too.
Yes. We've spoken to Apple Translator, but if she's available, I prefer that. Just to confirm.
He can sign a $1,500 signature bond.
Can you tell him that?
I'm sorry, I couldn't hear you. I heard $1,500. It's the final $1,500. Would you please repeat it?
$1,500 signature bond.
Thank you. Значит, у вас установлен залог
Yes,
на
what?
$1500,
Never mind.
чтобы вас
Yeah.
выпустить. Пожалуйста, подпишите данный документ.
Okay, bring it back here. We have another case with a gentleman that speaks Russian. He has a lawyer. Can you stay on the line and translate for him? They're going to be talking outside the courtroom, so I won't be involved, and the court won't be involved in that conversation, but the attorney's requested a translator for that conversation. And you can charge it to the court. I don't know how the Supreme Court does this, if they charge it to our court, but it's under the same court.
Okay.
Thank you very much. Okay, that's all for Mr. Bosman.
That's when you come back.
Yes.
State of Ohio versus Kelsey T. Wolf Gibson, case number CRB 24128.
Ma'am, are you Kelsey Gibson?
Yes.
It's alleged that in Fayette Township on March the 16th, you purposely deprived Walmart of property without the consent of Walmart. That's a theft offense, maximum penalty 6 months in jail, $1,000 fine. You understand the charge?
Yes, Your Honor.
You understand the rights you have?
Yes.
How do you plead to this?
Not guilty.
And you want a lawyer appointed?
Yes.
Are you working?
Yes.
What do you do?
FedEx driver.
Okay, well, you're probably going to be making too much. What, are you paid by the hour? How do you get paid?
Yeah, I get paid $14 an hour.
14? No, I thought they made a lot more than that.
No, I wish.
How many hours a week?
40.
So you're making about $29,000 a year gross?
I guess.
Okay, well, that's what $14 an hour, 40 hours a week, 52 weeks a year is.
Okay.
Any dependents?
No.
Okay, that's still too much for a single person. If you had a child, then I could appoint a lawyer for you, but for a single person, I can't appoint a lawyer. So, you've got a bond up with Mr. Soward, so I'll continue that. I'm entering a not guilty plea for you. And this is the co-defendant of the other person, so I think I set that for April 1st.
Yes.
So I'll set yours the same day. April 1st at 10 o'clock. And I indicate you will hire counsel. Any questions? Okay, I'll be back here April 1st unless your lawyer tells you you've got a different date.
Okay.
Okay, that's all. Not guilty, please.
State of Ohio versus James G. Adams, case number CRB 24130.
Sir, are you James Adams?
Yes, sir.
Mr. Adams, it's alleged that in Windsor Township, March 17th, you not only caused or tried to cause physical harm to John Blevins. That's an assault charge. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir, but could you repeat his name?
The complaint says Bevins, not Blevins. B-E-V-I-N-S.
Okay.
You understand the
Yes,
charge?
sir.
You understand your rights?
Yes, sir.
How do you plead?
Not guilty.
You want a lawyer appointed?
No, sir.
You gonna hire a lawyer?
Yes, sir.
How much time do you need to do that?
30 days, please.
I'll set your next hearing for April the 19th for a pretrial at 10 o'clock. Indicate you will hire a lawyer.
Yes, sir.
And is there a protection order requested?
Yes, Your Honor.
Is there any problem for you to stay away from Mr. Bevins?
No, sir.
I'm ordering that. That's to be a part of the court's order. You'll sign a protection order, wait around, get a copy of that, take it to your lawyer. It just says stay away, no closer than 500 feet. Don't post anything about this gentleman or the incident. Just let things die down.
Sir.
Okay. April 19th is the next hearing, 10 o'clock.
Yes, sir.
He already has a bond.
He does have a bond up, so that's continued.
Your Honor,
That's all.
thank you.
You're welcome.
State of Ohio versus Nahum C. Lopez, case number CRA 24133. Nahum Lopez.
Nathan Lopez, you can speak English?
Yeah, a little bit about that.
Your Honor, he can speak a little English if he'd like to translate, it's all right.
All right, can you identify yourself, sir, the translator?
My name is Aurelio Hernandez.
Hernandez?
Yes.
And do you have a relationship with Mr. Lopez?
We're just friends.
Friends? Okay. Mr. Lopez, are you okay with him translating for you?
Yes.
Okay. Let's start with rights. He has a right to remain silent. Tell him that. He does not have to say anything. But if he does say things, it's on the record. It could be used against him if he admits something.
Pero si tú vas a contestar, va a ser todo en tu contra.
He has a right to have an attorney.
Que tienes derecho para regresar de vuelta si en caso pasa.
He has a right to have an attorney appointed to represent him if he can't afford one.
Que tienes derecho que vas a tener un abogado después, pues en caso si no resuelve nada.
He's already posted bail. He has a right to bail, and he's already posted it.
Que tienes todo derecho
He has a right to make the state of Ohio prove the charge beyond a reasonable doubt.
que tienes derecho a todo lo que esté aquí en el estado de Ohio, de las cosas que vas a decir.
Does he understand those rights?
¿Entiendes todos los derechos? ¿Es lo que te dije? Sí. Yes.
He's charged with receiving stolen property.
Que tienes cargo de eso de la...
It's alleged that at Perry Township on March 16th,
March 16.
March 16th,
Vas a tener marzo 16.
he received a pistol, black Taurus pistol, 9mm, that belonged to someone else.
Que la pistola que te encontraron son 9 milímetros y que eso estaba robado.
That he either knew or should have known it was obtained by theft.
Que no debe cargar eso.
The maximum penalty for this is a year and a half in jail and $2,500 fine.
Que puedes ir a la cárcel como un año, 4 meses y de la fianza, bueno, de la pensión de $2,500.
Does he understand the charge?
Si entiendes las cargas que te están dando.
See? I need a verbal response.
Contéstale, sí.
Does he have the money to hire a lawyer?
¿Tiene dinero para contratar a un abogado? Yes.
Has he hired a lawyer?
¿No tienes abogado ahorita? No.
How much time does he need to hire a lawyer?
¿Cuánto tiempo puedes conseguir un abogado? ¿Ahorita mismo? No, en este tiempo. Un mes. Like a month.
How much?
30 days.
He has a right to have a hearing within 15 days if he wants, but I can go longer if he needs more time.
Que dice que ellos te pueden dar un abogado aquí por 15 días si quieres o quieres contratar aquí en 15 días. They want to have it here for 15 days.
He wants to come back in 15 days then?
Yes.
I'm going to set it for April 1st. That's 2 weeks from today.
April 1st.
April 1st.
At 10 o'clock will be his next hearing. It's called a preliminary hearing. His bond is continued.
I have a question.
He has a question, Your Honor.
You have a question?
Yes. He wanna know if he paid like right now to the money or they still need to come back from the court.
He'll need to come back to that hearing with a lawyer.
Okay.
Yeah. Any other questions?
No, the bill.
Yeah, that's all.
Thank you.
You're welcome. Okay, we're back to pre-trials.
State of Ohio versus Zachary R. DeMint, Case number CRB 23101, CRB 22553, CRB 23506.
And this is Mr. Thompson's case. He's at Shawnee. It's a good report, making progress, still stuff to work on. It's my take on it.
Yes, sir.
He's doing great. He's an amazing client.
Good. So continue the course that he's on and come back and monitor it in the future, maybe a month out. April 22nd. April 22nd will be the next hearing. Pre-trials, 10 o'clock.
Hey, Capper, I decided to go ahead and do transitional with Shawnee, so I just wanted to let you know.
Okay, that'll be good. Just whatever they recommend, you all in agreement with, I'll go along with, as long as you're compliant.
Yes, sir.
Thank you, Your Honor.
Thank you.
State of Ohio versus Kevin Dale, case number CRB 23736. Your Honor, this is the case where Mr. Ashworth is special prosecutor.
All right, Mr. Ashworth is special prosecutor on this. Sorry to keep you waiting, Mr. Ashworth. It's set for pre-trial today. Mr. Morford is counsel for Mr. Dale. My notes were it wasn't resolved today to set a trial date.
Judge.
We've had some discussions since then, Your Honor. Is the victim in the room?
And that would be Paul Brackett.
Brackett, Mr. Brackett.
Paul Brackett here today? Paul Brackett. Apparently not. I'm not getting anyone coming forward.
Mr. Brackett and I have had discussions, Your Honor. He would like for the protective order to be dropped, and I've discussed the case with defense counsel. We were going to continue the case for 90 days, and if there's the defendant and Mr. Brackett, then I will dismiss the charges of the victim's request. I will I guess he'll go to the prosecuting attorney's office and fill out some paperwork that has an effective for trial, since he's not in court.
All right, do you agree with that, Mr. Morford?
Yes, Your Honor. Mr. Ashworth and I talked earlier today, and I believe that's agreeable with Mr. Dale as well.
All right, so I'm going to set it out for June 17. And if there's no further problems, it'll be dismissed then. Mr. Ashworth, that's the agreement?
Yes, Your Honor.
No further problems, will be dismissed on June 17th.
No cost, Judge?
Yeah.
Hasn't been asked for, so no.
Thank you.
Thank you. Yes. You don't have to appear unless there's a problem, Mr. Ashworth.
Very good.
Thank you.
Thank you, Judge.
State of Ohio versus Sean Ratcliffe, case number CRB 23730. I think he's also on Zoom, Your Honor.
Okay, Sean Ratcliffe is appearing by teleconference. His attorney, Mr. Thompson, is here. It's set for a pre-trial.
We've arranged with the prosecution for a change of plea based on the joint resolution being 30 days jail suspended, 5 days community service, which will be taken care of wherever he is. I believe it's in Virginia. Is that where you are? Virginia? John?
Yes, sir.
Okay. $100 fine and court costs.
That's the recommendation, Mr. Hill?
It is, Your Honor, and as far as the community service, I've let Mr. Thompson know that there's going to be Mr. Ratcliffe's responsibility to make sure that it passes the approval of your probation department.
Yes. All right, Mr. Ratcliffe, did you hear what's been recommended to the court?
Yes, sir.
Are you in agreement with what your attorneys represented to the court?
Yes, sir.
Anything you want to tell me before I finalize your sentence?
No, sir, I appreciate the court allowing me to do a video appearance today.
You're welcome. All right, I'll accept your guilty plea and impose the penalty that's been recommended, which would be a $100 fine and court costs. 30 days in jail, all suspended on the condition to do 5 days of community service. That's 30 hours of community service. 2 years of level 5 probation. A review hearing on September the 16th at 9 a.m., September 16th. If you finish everything by then, you don't have to worry about appearing. If you haven't finished it, you got to come and explain why you didn't get your community service and fines and court costs paid by them.
Yes, sir.
Any questions, Mr. Ratcliffe? Okay, no, that's all then. You're excused.
State of Ohio versus Joseph E. Green, case number TRC 24151, A, B, C, D, and E.
Your Honor, we just filed for discovery today, so we'd like to ask for continuance. Maybe about 3 weeks out.
That's the 8th of April. April 8th will be the next hearing, pre-trial, 10 a.m.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
That was April. I'm sorry.
April 8th.
State of Ohio versus Jason McCoy, case number CRB 23537.
They're going to stay together this time or not?
Who's in?
This is the main case.
What's the name on it?
What's your name, ma'am?
Aaron.
Is do you have an attorney, man?
He's not here.
That's right. Your attorney's not here, I just texted him, and that's. So let's,
We have a report, Your Honor, on my client from Pat.
we'll have to call your case later, man.
Okay.
Where is this from? It's not even on letterhead.
It's from Hunter. He sent it to the email. He wasn't in the office.
Oh, it's from Pat?
Yeah, from Pat. I apologize. And whenever we ran out of the house, I forgot to print it, so I had to stop at the library and print it.
You can get me another copy.
Yeah, I can see no team.
Okay.
How's the state want to proceed?
If I remember correctly, they were both, he and Miss Erin McCoy, who's not before the courtroom just now, both in counsel, I think.
Correct.
And I don't know whether she was going to PATH also, or...
She's here, but her lawyer's not.
Yeah.
Have you heard anything from Sean Stratton?
Have not.
The last time he was here, everybody was sick.
Can you have the clerk try to call Mr. Stratton? I sent him a text, but he hasn't responded.
Yes, I will.
As for Mr. McCoy, we're
Yeah.
satisfied with his progress at PATH. It sounds like he's doing well.
She has a report also, Your
And
Honor.
this is not the only case, he's got several cases on the docket.
That's fine. That's fine. Did you say there's other things besides this case involving Mr. McCoy? I don't know what those
No,
are.
Mr. Stratton.
Oh,
Mr. Stratton's got several cases on the docket. He's not here, and he hasn't responded to the text. I'm having the clerk try to call his office to see what's going on.
well, I guess what we'd like to be able to do is kind of address the situation between Mr. and Mrs. McCoy mutually. So I don't know whether that can be done without him being here or not. I'm assuming she's got a good report too.
He's here. Okay.
Sorry, Lon. A little late this morning, Your Honor.
All right, Mr. McCoy, you can come on up.
Sorry about that. It's one of those mornings.
Good morning.
Good morning.
State of Ohio versus Aaron McCoy, case number CRB 23-5.
Hers is on letterhead, and it is a good report.
Yes.
Actually doing anger management. Or doing the cooking skills and stuff like that.
Yeah. And they offer marriage counseling as well.
Looks like each of them have made significant progress. One of the things that we did have an initial concern about, which I would like to know a little bit more about, was that when this happened, Children's Services became involved. I don't know whether they're still involved with them or not.
It's been resolved.
Okay, that's what I thought. So I guess the question is whether they've reached a level of assistance from PATH that they can continue on without the court being involved. We had agreed to a dismissal once they completed their counseling. We also realized that there's counseling that maybe people need to continue with even if they don't have to come to court about it.
Very true.
And we would hope that they will, because hopefully they've recognized an improvement in their circumstances. Makes life better. So we've been at it for several months. And we wouldn't oppose at this time a dismissal of both of the charges if there's a payment of one court cost.
We're in agreement? We're in agreement too, Your Honor.
Who's going to pay the court costs? All right, it'll be on Mr. McCoy's case, dismissed with payment of costs on his case. And you can you do that today, sir?
How much is it?
The 125 plus 35.
One what?
125 plus 35.
Yep. 65. Hers will be dismissed outright with no cost.
Thank you.
See you tomorrow.
Thank you.
State of Ohio versus Adam C. Reynolds, case number 23-400.
Thompson's case set for pretrial.
I don't believe we're going to come to a resolution with the prosecutor, so I will set this for trial, please. At about a month and a half out.
May 10th? Well, no, there's a jury trial there. May 6th?
Is that a Monday?
That's a Monday.
Thank you.
May 6th at noon for trial.
State of Ohio versus Kirsten Shipman,
Thank you, Your Honor.
case number CRB 23698.
Thompson's case. She is at hometown.
I'm
She left our
at-
facility ASA, Your Honor.
Okay.
And if I may speak, Your Honor,
Talk to your lawyer. Probably.
I know what she's going to say. Go ahead.
our, I think Miss Ann is her name, she said she got in contact with you, letting you know that I was in Regal. Because, if I may, when I first came in here, obviously I didn't want to get clean. I was doing it for the court. And some point or another, I actually found myself starting to do it for myself. And I just didn't feel like hometown was where I needed to be. But I've already got a job interview on Wednesday, and I am still sober and doing the treatment thing the right way.
Well, let's have you do a urine screen today.
Okay, that's fine. I haven't peed just because of that.
Okay, go do a urine screen.
State of Ohio versus Christopher Blackard, case number TRC 171226, A, B, C, and D.
This is Mr. Stratton's case now set for pretrial.
You want to recall it? It's a 17 TRC case. Well, I don't know if we have. Okay. Your Honor, this is a 17 case. We'll have to dig out the file. Unless I can look at the court's file.
Well, it's on the pretrial docket.
I understand.
You guys want to recall it, Your Honor?
Yes.
Let the state get their file.
We'll recall it.
Blackard 17.
Just one second. Have a seat.
Case number is 171226.
Yeah, have a seat.
State of Ohio versus William T. Green, case number TRC 231715, A, B, and C, CRB 23686, and CRB 23692.
Mr. Stratton's case set for pretrial.
Your Honor, I'm not sure where Mr. Green is. He's been in communication with me, so I will send him a text message, see where he's at, see if I've received any from him. I just saw the court's text just a while ago, so.
I don't think he was here on March the 8th either, was he? I mean, I think we continued it then because he didn't appear.
Yeah, so,
What's the state's position on this?
Well, given the fact that this is the second time, we would ask for a bench warrant.
He's got 7 days to get in before warrant issues.
yes, Your Honor.
State of Ohio versus Joseph R. Sherman, case number CRB 24-113 A and B, CRB 23-248.
This is the first pre-trial, that's one. Let's see what your take on it is.
Well, Mr. Stratton's
I
case.
tried to let him last week, said he was in trouble.
Yeah, it was. Your Honor, may I approach?
Yeah.
What's this?
Court costs. Yeah, I paid on it Friday. I was supposed to be here then.
Okay, great. And he's paid some on court costs too, Your Honor, already, so keep on with that.
So, Your Honor, Ms. McComas is here. She's the alleged victim. Now, we have a pretty grave concern about this situation because of charges that were before the court just back in January.
Those went to the grand jury and got dismissed there, right?
They did, and that does
In
not
her
cause...
instance, I think.
Yes, and that obviously doesn't cause us to think none of that happened, just that it wasn't proven beyond a reasonable doubt. Now we're back again, but Ms. McComas wants to have the protection order dismissed, and she wants Mr. Sherman, she has some doubts about whether PATH is having success for him, whether it's being effective for him, that she feels that he needs some more serious intervention. I don't know what that would be at this point.
I mean,
You got a pretty good report from that.
yeah, I mean, if there's something additional, I don't know what that would be, and maybe suggestions would be something we can look into. But PATH is pretty good. I mean, we've always used PATH for these purposes.
I mean, is he happy with what they're doing with him? I mean,
Yes, I asked him to up my medicine, so we're going to be doing that here soon.
he's welcome to seek other medical attention. I mean, I think this is, at least there's some effort being made to meet his issues.
Yes.
I guess, and I'm told by Ms. McComas that she's actually attended some of the sessions, and maybe she could explain it better than I can explain it for her.
I just feel like he needs to see like a psychiatrist more regularly than just a therapist.
Well, he's free to do that. I mean, I don't know what's available. I'm assuming he has a medical card, and if has he had a psychiatrist in the past that he has gone to?
I'm not really for sure, not to my knowledge. I know he sees one every so often,
See
but
more if that will help.
He's seeing a nurse practitioner and a psychologist, I believe, at PATH. Is that right?
Yes, I believe so.
He's getting meds. They're prescribing him meds here.
He's willing to do whatever is necessary to resolve the case. That's up in who he sees, how many times he sees them. He's willing to do that. That helps.
Well, so as I understand, ma'am, you're wanting to, there's a relationship between the two of you, and you're wanting to continue that. And you don't want a protection order.
no, sir.
Well, he's free to go to, and you can, I guess, advise him or help him. Maybe you all could go together for additional medical care. I don't think I ordered him to go to PATH to begin with. I think that's something he chose on his own, I believe.
Yes.
So the court's not going to be upset if he decides to go to another facility for additional care. My main concern is mostly for you. The last allegations were pretty darn serious. So I don't know, I mean, these are too, but the last ones were even more serious, and I'm concerned for your safety. You're an adult, you get to make choices yourself, even if they're bad choices. But there needs to be some changes made, at least if there's any truth to the allegations that have been made before the court in the past. There has to be a different direction taken in this relationship. Do you agree with that? Okay. Is it happening?
A little bit.
A little bit. Well, from what I saw in the past affidavit, what I read in the past affidavit, there needs to be a lot of change made.
Yeah.
Violence is not acceptable in any fashion. That's not a way to resolve conflict. Any relationship there's going to be disagreements, you don't resolve it by, I'm stronger than you, I can impose my will on you. Might does not make right. Do you agree with that? Okay, well, the two of you need to decide if you're going to go forward. I mean, I don't want to see you be the victim of any more violent acts. How are we going to make sure that doesn't happen going forward?
Well, Your Honor, he's, like he said, he's up to his medication, he's going to PATH. The more things he can do, the more things he's willing to do. He's willing to do more, whatever she would like him to do to resolve this matter. I believe the state is most likely going to be okay with this being pushed out a little bit to see how that progresses, and then go from there, because since it is probably resolved medication.
Is that what you want to do, Mr. Neal, Dan?
I'm making a lot of notes, because if something bad happens and somebody says, why did you let this happen, Mr. Neal, I'll be able to say why, because I believe that there's a danger of a big problem happening. I hope that Ms. McComas understands the situation clearly in her own mind as far as what needs to happen between her and Mr. Sherman. And I hope that Mr. Sherman's taking it seriously, understanding that he got by the skin of his teeth the last time in court with some very serious charges, and we take all this very seriously. We don't do this frivolously. And I think maybe that Mr. Sherman and Ms. McComas need to have a discussion with PATH maybe about what other concerns she has. Hopefully they will understand and provide something more if it's needed. Maybe more contact with the doctor, I don't know. Obviously, we're not in a position to know, but.
If I may, I have an appointment this week. She could come with me and see Jeremy West.
So hopefully they'll take that upon themselves to make sure that we don't end up back here with something worse.
Well, I think if you're going to continue this relationship, it's good that you be involved and go with him to his sessions.
Yes.
And perhaps you can participate in some sessions yourself. Maybe come back in a couple weeks and see where we are.
Yes, sir.
Are you available to come back, ma'am? You don't have to, you're not a defendant, but
Yeah.
April 1st?
Yep.
Next hearing is April 1st for pre-trial.
Your Honor, Mr. Smith and I and Mr. Hill approached between cases briefly.
When are we coming back on this case, Your Honor?
April 1st. I put them all, so good. Okay. You're trying to represent the one. What we have is Smith's client. And you would say, translator, tell you, my guy, you're going to do yeah. Young guy said that he would be willing to plead. He doesn't have money to cost me, I'm going to pay that for him. He said that. We don't have to conclude it today. That way we can have some time to figure it out. It's like the siren, it's the opposite. Walmart's like the siren that calls the service center. People go there all the time to shoplift. Why? That big sign on the front, of course, please carry loads. Bring it back. That's okay. That's okay. I'd rather 81.
State of Ohio recalls Kirsten Shipman, case number CRB 23698.
Okay, it's an appropriate screen. I'm not happy about her changing providers. It's not something you just get to take on yourself and decide. You said, well, I got a text. Yeah, I got a text from her saying you arrived there Thursday, not without, I didn't approve that. I didn't allow you to go there. You just took it upon yourself to do it. So, that's not how it's supposed to be done.
I'm sorry, I have talked to, I'm sorry.
So, and this is inpatient, you're inpatient
Yes.
here? Well, at least your screen is okay, because otherwise, you're probably gonna go to jail. If you'd shown up dirty and changing providers, I would put you in jail. So, we'll try this for a while and see how it goes. April the 8th. April 8th will be the next hearing.
Thank you.
10 o'clock.
State of Ohio versus Emily A. Smith, case number CRB 23627.
Is that from?
Mr. Stratton's case, pre-trial.
You're in hometown, aren't you?
I'm at Minute
Minute, okay. Minute Reeds? Is there a letter?
She's only been there, it's been less than a week.
Less than a week, okay. All right.
Yeah, she just went there at the beginning of this month, I think.
Yeah. So, Your Honor, I think there's some things that she would like to just discuss with the court. And I think that one of the things she would like to discuss is possibly do an outpatient instead of inpatient. But I'll let her talk. Go ahead.
Your Honor, I've been clean for 4 months, and I've been in treatment for 3 months, and I'm missing my family, and I'm willing to do everything I'm doing in inpatient and outpatient, if that would be okay. I have a home to go to. My mom already said that she would accept me back.
She was discharged from hometown recovery. So no. I'm on approval. It's either jail or go to stay in inpatient. Which would you prefer?
Definitely inpatient, Your Honor. I could probably speak for her on that issue. If she does very well at Mended Reeds and gets further along in the program, maybe the court could consider her for outpatient at that time.
Yeah, I'm not going to reward bad behavior for getting kicked out of another facility.
May I speak, Your Honor?
I don't know if it's advisable. You probably should tell Mr. Stratton.
Wait one second. Okay. Are you on any medication for that?
Yeah.
Okay. Does that not help?
No, I'm trying to get it all taken care of.
Okay. Who do you go to see for that?
Mended Reeds.
So Linda Reed's helping you with that? Okay. Your Honor, she does have some medical issues, extreme social anxiety, PTSD, I guess, that Mended Reeds is helping her with.
She's at a good place to get that dealt with.
Yes, yeah, that's why I just asked. So I just let the court consider that. She's just a little on edge, I think, right? So,
I think she's where she needs to be.
Yes. Okay.
Let's come back on April the 8th for her also, see, get her an update.
Thank you, Your Honor.
You're welcome.
Ask them, okay, you're on medication, but that does not help you. Don't go too long, okay? All right.
State of Ohio versus Charles Martin II, case number CRB 23484 A and D. Mr. Walker's case.
Here's Sean.
And Mr. Martin's at RRS. He's completed at RRS.
Yes, sir.
Just recently, the last few days.
Yes.
domestic violence, okay. And what about the other one? The resisting arrest, no jail time. What do you suggest? Well, if you pull away from them, you're resisting it anyway. Like the boat. Yeah. Like a fine, a fine, no. It'll be a fine, yeah, but no court, no, okay. Okay.
There's also resisting. He put for that.
Judge, I believe we have a recommended agreement to present to you for your approval. Mr. Martin has completed or as outpatient services as he agreed to do. The state, I believe, is willing to acknowledge the domestic violence in exchange for a plea to the resisting arrest. They would not ask for any jail time on that plea.
Is that correct, Mr. Ewell?
It is, Your Honor. We had, of course, consulted with the alleged victim on this over the course of this case, and the desire was for this to happen, for him to complete the counseling. We would dismiss the charge, but we would insist on a plea to the resisting arrest, and our recommendation on that would be 30 days in jail suspended.
Mr. Martin, anything you wish to say to the court before I finalize things?
No, sir.
Okay. Well, I've got something I want to say to you. Congratulations, and you've done really well in your treatment.
Yes, Your Honor, he did extremely well.
Thank you.
I appreciate that, and I hope you stick with it. You know, whatever you need to do to stay clean and sober, that's what you need to do in the future, too. You've made a lot of progress. So I'm going to dismiss, I'm happy to dismiss 484A, which was the domestic violence charge. That's dismissed. You're pleading guilty to resisting arrest. And because you've done so well on your treatment, I'm just going to give you a $75 fine and court costs on that, with a 30-day suspended sentence. So my intention is you won't serve any time. You just pay your fine and court costs, and that's all. You can work if you can't afford to pay. You can do extra community service. You get $50 a day credit, and I'll let you work your costs off too. Do you have any questions, sir?
No, sir.
So it'll be 2 years of level 5 probation with a review hearing on September 16th. You'll need to check in with Mr. Mason before you leave.
Not reporting. How long do I got to take? They'll work with you. There's when you come out at 9 o'clock on this.
Yep.
Thank you.
You're welcome.
Thanks.
Thank you, Your Honor.
State of Ohio versus Darren L. Coleman, case number CRB 24986A and B, and CRB 23761.
All right, Derek Horn is Mr. Morford's.
Your Honor, Mr. Gordon has had some troubles adjusting to treatment. I do believe that there is a failure to communicate somewhere. Like, I think that he wasn't understanding correctly the switch of the counselor. I have spoke with him outside. He has apologized for his behavior. And I think he was under the impression the charges were going to be dropped that day, and anger came out in a different way.
May I speak, Your Honor?
Ask your attorneys.
I just want to offer my apologies to you. I just, first of all, want to offer my apologies to you and your court. I've apologized to Mr. Morford and Mrs. Jones. I don't want the impression to be that me speaking on my behalf was done in anger or resentment or wanting things to go my way. I thought I was coming with proactive solutions on behalf of what Victoria was asking of us, which was me attending anger management and couples counseling. And I was placed in a program where I wouldn't be able to work, which is, you know, I mean, the main thing that she was wanting me to do was find a job and, I mean, be a healthy partner in our relationship.
Well, maybe we need to get some input from her, from the state.
Well, Your Honor, and we've done quite a bit of discussion on this. On Friday, Your Honor requested that we have the arresting officer here with respect to the resisting arrest, and he's here, and I've spoken with him, and, you know, he feels that it was a pretty serious situation, right? We believe that all of this has been very serious, and especially since there's a young child that's been in the mix, that we most, you know, where'd Tori go? There she is. She's an adult, but we have a child involved in this. So we have a recommendation as to how to resolve this. We're not going to dismiss anything, but if Mr. Korn were to plead guilty to all the pending charges, we would delay the sentencing. Apparently he has a job maybe in Virginia or something he wants to go to. We'd hold the case over for sentencing for 90 days. The protection order would stay in place. And if there weren't any problems in the next 90 days, we would not recommend jail time. We'd recommend a suspended jail sentence at the end of 90 days.
It is his intention, Judge, if permitted to do so, to go work on an oyster boat?
Yeah, I'll be doing fishing.
With your cousin?
No, he's just a friend of 20 years plus. He's willing to house me and help me and has a job waiting on me, a car that I can, you know, I mean, use for work and possibly buy with payments. And I would like to say that I'm not doing this with the intentions of leaving Victoria. I just want to put some distance between us, both of us work on ourselves, and the counselor with ANEW said the couples counseling would still be available through Zoom, and I would just hope she's willing to do that. Again, I'm not doing this with the intentions of anything but working on myself while I hope that she does that with the intentions of reuniting with me, because above all, this is a mental health situation that I want to solve, because us communicating, it shouldn't get to where it does, and it's solely my fault, and I want to figure out why.
All right, Ms. Bolton, do you have any input you want to give the court?
I think Virginia's a good idea, and us both working on ourselves. I don't know how we would do counseling if he's in Virginia, but I would be willing to do some type of counseling, but I think for now, distance and us both working on ourselves is probably for the best.
Okay.
I have to say I agree.
All right, so it's my understanding then there's going to be a plea, a guilty to case number 23-761, which was a domestic matter, and 24-96 A and B, which was a domestic and a resisting, I believe.
Yes, Your Honor.
Or menacing and resisting and menacing. And then I'm just going to delay sentencing. There's going to be, hold it off for sentencing for approximately 90 days. Mr. Korn can be released from Bethesda. Do you still have the GPS on? So obviously we have to take that off, but you still want, in this 90-day period, you still want an order for him to stay away, is that correct?
At least for my daughter.
Okay. And what is her name?
Charlie Mitchell.
Charlie.
Are you going to introduce domestic activities?
Would the domestic plea, would that hinder us being able to live together at any future point?
No, that's going to be up to her.
We'll see how counseling goes. We'll work from there.
But if I enter if if I enter the plea, that is a guilty plea, even though it's delayed sentencing, that domestic between me and her is gonna be on my record.
Yes.
That's correct.
Judge, would you like to recall this and let
Yeah, I'll give
me
you time to
answer
talk
his
about it.
questions?
We'll recall it. Raise your ear.
State of Ohio versus Estrogen Bozmanoff and
We're going on the record now, can you hear me?
Mr. Morbakoff.
Yes, we're going on the record now, just make sure you can hear me, okay.
So
Hang
we
on just a
have,
second.
we're back on the record at the request of counsel, Mr. Stiles, who's going to be representing Mr. Bosmanoff. Mr. Smith was appointed to represent Mr. Morbakoff. They requested it be brought back before the court before the scheduled date of April 12th, because it's my understanding there's been an arrangement worked out to resolve this with a plea of one of the defendants.
I believe so, Judge. There would be a plea based on my client would enter a guilty plea. As I understand it, Mr. Steyer's client was there but was unaware of what was happening. So I think the state, in return for guilty plea on my client, would dismiss the charge against Mr. Steyer's client, and they are prepared to pay. My client's prepared to pay the fine and cost today. They live in Cincinnati, he does at least, and I think the fine and cost in this matter, to stay out of landlord order, no probation, if you would pay the fine and cost, it would resolve this.
And to clarify, I believe they have to go to an automatic teller to get the money and come back to pay. Because we can't use a card directly at the clerk's office.
All right, since Mr. Morbakoff is the one entering the plea, let's ask the translator to ask him if he understands what's taking place, if he has questions.
Can you ask my client if he understands what's taking place here today? Correct, yes. He's right here.
Yep.
He understands, he said, yep, okay.
And ask him if he has anything he wants to say before I sentence him.
Does he ask if he has anything he wants to say before the judge sentences him? Oh, yes, could you ask if he has anything to say before the judge passes sentence?
Yordam berishini aybimizga iqrormiz. Bu holat qayta olinmasligini so'raymiz.
Okay, so I would like to ask for his help. Yes, I do plead guilty, and this mistake will not be repeated anymore.
Thank you.
I didn't understand what you said.
She said this mistake will not be repeated. She wants to plead guilty and this mistake will not be repeated anymore.
Okay. So the case against Mr. Bosmanoff, I don't think we need to translate because his case is getting dismissed. So I don't think we need to translate that since he won't have a case any longer. His case is dismissed. On Mr. Norbakoff, I'll impose a $100 fine, court costs, 10 days in jail, suspended, order to stay out of Walmarts. Since he's living away, I'll suspend the community service requirement.
Thank you, Your Honor.
You'll need to check in with Mr. Major. His review hearing will be September 16th. 2 years of level 5 probation.
Could you tell me level 5?
If he pays the fine and costs, he doesn't have to come back for the review.
Hang on, I'll get you just a second. What was the review date, Judge? I'm sorry.
September 16th.
September 16th. 9/16. Thank you, Judge. I've got to speak with him.
It's an 081 reference. And he's also got a driving under suspension charge, so does he have a valid license now?
State of Ohio versus Sean Woods, case number TRC 23-811, A through D.
I have Mr. Cummings as the attorney on this. Oh, I think this was sentencing because he has a bond up now.
Yes.
So we got a report from RRS. He tested positive for alcohol.
Yes, I screened him myself, Your Honor. I've spoken with his counselor and let her know that he was positive for alcohol.
Well, I don't think we're making much progress, are we? I think I'm gonna just go ahead and sentence him. And you don't have a lawyer any longer, Mr. Woods?
I did. I paid for the lawyer. I don't know where he's at.
Well, let me text him and see if he's still considers he's representing you. Okay, we'll recall it. Text him right now to get his response.
State of Ohio versus Christine Conley, case number CRB 2487. Your Honor, that's Mr. Steyer's case.
Mr. Steyer, I think, is out in the lobby.
He's coming to this thing.
Your Honor, based on discussions prior to, well, this morning, Ms. Conley's prepared to enter a guilty plea at this time. The state and the defense are going to make a joint recommended sentence of 10 days in jail, suspended with a $100 fine and 30 hours of community service, and a probationary period at the court's discretion.
Do you agree with that, Ms. Conley?
Yes, Your Honor.
Do you have anything you wish to say?
No.
I'll propose what was recommended. She's changing her plea to guilty.
Yes, Your Honor.
The $100 fine costs, 10 days in jail suspended, 30 hours of community service, order stay out of Walmart's, review hearing September 16th, level 5 probation. She's to meet with Mr. Major and she's free to go.
Thanks. You go out and I'll that guy out there and he'll get to you in a few minutes, okay? He's got to get your file, just so you have that for you.
State of Ohio versus Tanya Lanhart, case number CRB 23447A and B, TRD 23963 A, B, and C.
And this is Mr. Steyer's case.
May I approach? Do you need these back or these are copies?
No copies.
May I approach?
Yes. Excuse report and certificate of completion from Mindy Reeves.
She's still there in transitional, Your Honor. She's doing very well. She's doing extremely well in treatment and QRT.
Very good. How's the state want to proceed on this?
These are misdemeanors. Can she stay on QRT if those charges are dismissed? So I think, given the fact that she's completed that program, she's being overseen by QRT, maybe it's appropriate to do that today.
So dismissal to QRT?
Yes, Your Honor.
Okay. At this point, case is dismissed to QRT. You respond to them only, and you won't have to come back to court for any further hearings unless you mess up and they send you back.
Thank you, Your Honor.
Thank you.
Good luck.
Good job.
Thank you.
State of Ohio versus Michael Davis, case number CRB 2490A and B, CRB 2428, CRB 23776.
Your Honor, this matter was not on the docket, and Mr. Davis is not here. He's actually in inpatient rehab at this point. But the alleged victim has shown up today asking to have the case called so she can request the protective order be dismissed.
Is that correct?
Yes.
State's position?
Well, she's an adult. We're still serious about making sure that he gets his treatment. She says he's doing well. I guess he's at OVP.
I don't know. I think he's doing well, but I haven't been able to talk to him until he gets dropped.
Well, you're hoping he's doing well.
Yes.
Okay, his next hearing is April 5th. At this point, at your request, ma'am, I'm going to go ahead and withdraw the protection order.
All right, thank you.
We had a hearing on the 22nd, but that's been moved to the 5th, am I understanding that correctly?
April 5th is what I'm showing.
Okay. Then I'm going to take him off my calendar for the 22nd and just move him to the 5th. Thank you.
State of Ohio versus Shannon S. McPherson, case number CRB 2439. Your Honor, that's Mr. Roger Smith's case. And we have one of those that's also dismissed. Where he is.
He was in the lobby
Roger Smith.
speaking to this.
He is in the law.
Those
He's
guys
just
arrived
before,
before, so.
Judge, this is a case, there is a, I won't call it co-defendant, a child involved who's got a juvenile hearing tomorrow. I spoke to Mr. Hill, we'd like to come back on this, see what happens tomorrow. She's got to attend that hearing. I could be here the 29th of March or the 5th of April or the 8th of April, whichever's better for the court.
The 8th of April.
10 o'clock.
April 8th, pre-trial at 10 o'clock.
Thank you, Judge.
Thank you.
State of Ohio versus Leslie D. Southers, case number CRN 23708.
My question is,
RRS.
well, they shot me.
Yes. my understanding, is there issues with Thrive also, or?
She was doing really well at first. The only issue that I have is that she tendency to forgets that I need to meet with her once a week. I did try to call this week to meet with her, and I didn't get a response until later that evening. And she wanted to meet on Saturday, which I'm off on Saturdays. I do agree, Bobby and I spoke, she does need some serious time management skills, and she does need to utilize a weekly schedule to access all her recovery appointments and meeting with me as well.
Okay, so there's still stuff to work on.
Yes.
But looks like we're making some progress, and I went back and I'm looking at her screen back in January, so we've made progress since then.
Yes.
So, I know at one time we were talking about whether she could continue outpatient or she needed inpatient. What's the recommendation there?
So my recommendation right now would be to continue outpatient, but you have to remain compliant.
I was working on the 2 days that I didn't get to make it. It's hard, my scheduling is hard too, trying to work too.
Do you have a cell phone?
Yes, I do.
I don't understand if you get a text or contact from Juanita, why you can't call her back.
I do, but it's usually after I get off work and then she's off work, so our scheduling is not, I don't know the word for that.
What do you say, Juanita?
I always set up at the beginning of a week at a time that we can meet. And when I had put the initial call out on the day we can meet, that is to confirm that you are still meeting with me. And then when I don't get a call back, then, you know, I don't travel to go meet. That's...
Okay, well, you need to act like you don't want to go to the inpatient by knocking it out of the park on outpatient, and then you're not doing that. Because at one point, that was the whole question. Do you need inpatient or outpatient? So I'm not convinced that we're getting where we need to go.
I mean, it's hard.
Come back with better reports next time, okay? That's what I'm saying. You need
Okay.
to, if you don't want to go inpatient, give me some better reports next time.
Okay.
Judge, I'm here any day in April except the 22nd and 26th. Those are, that week I'm bad.
April 19th.
I can do that.
Yeah, I do.
Better report.
Thanks, Judge.
You're welcome.
State of Ohio recall Darren L. Cord, case number CRB 2496 A and B.
I'm sorry?
When's her next court date, Your Honor?
April 19th.
I'm sorry.
And CRB 23761.
Mr. Morrison.
Judge, I believe that we have an agreement worked out for your approval this time. I believe the state is agreeable to amending the domestic violence charge to an assault charge. That would leave him pleading to that. He would also plead to menacing and resisting arrest. The restraining order injunction with respect to the young lady would remain in effect.
So the amendment's going to be on 23-761, was the domestic violence that's being amended to assault.
And Your Honor, I believe that that's probably technically more correct anyway. They don't have a child together. They spend time together, but apparently don't share a household, and they're not married. So I think assault applies.
Okay. And the threat, I think, was against the child anyway, was it not?
Yeah, that's right. Well,
Where's that threat against my child? And what's the assault? Like he yelled at me. Like, I don't understand what the
well,
assault
but we have, first of all, we have more than one case.
I know. Yeah, I mean, we have all.
This is the one from Christmas Eve.
Okay.
Can you give me that section?
And are we going to, is it going to fit? Is it going to be an assault?
Well, the domestic's an M4, isn't it?
Yes.
We can call that a menacing. There are two menacings.
This is the incident where you were in Ashland, he jumped out of the car, and you went off and left him, and then he somehow came home in a rage. And your daughter left the house because she was afraid.
She went to my dad's house, yes.
So you want to amend it to menacing?
Yes, Your Honor.
That's a lesser, anyway. That would be an M4. So that's 290322. 290322. So there's a guilty plea to that charge. That's the one from Christmas Eve. The amended charge of menacing, correct? Is that correct?
Yes, Your Honor.
Correct, Mr. Corn?
Yes, sir.
So then on 2496 A and B, that was the menacing. The B case is a menacing, and the A case was a resisting arrest, and he's pleading guilty to those.
Yes, Your Honor.
So I'm going to delay sentencing. Protection order remains in effect. He's allowed to leave the state. I think it would be good if you continue with some medical treatment.
I plan on doing so.
And then we'll set a date for him to come back for sentencing, and I'll be interested in hearing what Ms. Bowman's recommendation is in the states at that point. So we'll have 3 months to decide.
You're on.
I can, at that point, enter a no contact order if you decide I don't want any more contact with this guy. I can order that. Or if you want to get back together, I won't stand in the way. But you need to decide within the next 3 months what you want to do.
Is the no contact order in place for Victoria and the child, or just the child?
At this point, it's just a protection order to stay away from the child.
Thank you. So
I understand what you want.
Of course, I'd like to have a conversation before I depart with her.
So we're looking at June. Time to come back in June. Mid-June. So I would say maybe 24th or 28th, actually, a little toward the end of June.
Judge, give me, I think I'm good either day.
It stands as I'm allowed to go to Virginia, and 90 days I'll come back and determine sentencing at that point.
Yes.
Thank you, sir.
I'm good either day, Judge.
Okay, let's make it the 24th, June 24th. And I'll order the ankle monitor removed.
I'll have staff taking the common pleas to have it removed.
The sentencing then on June 24th.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio recalls Christopher Blacker, case number PRC 17-1226, A, B, C, and D.
I think we have a resolution.
Okay.
So, Your Honor, we were able to get a copy of the charges. The OVI was a .81 breath score.
Mr. Steyer still here? I'm not sure, Your Honor.
I'm here, Your Honor.
Okay, because Mr. Kermes just texted me, he said he thought you were covering for Mr. McCann on this. Mr. Wood.
Oh, I'm sorry. Is that the case that's been called?
Well, it was.
Oh, I was out dealing with that when it was called. I apologize.
Okay. You might want to talk with him.
I have spoken to him.
Okay.
I just didn't hear it called on the phone with the translator, I guess. I apologize.
All right, I'm sorry, go ahead.
The test score was .081. But his license was suspended at that time, and apparently he has no license now. So we would dismiss the OVI if there was a plea to the suspended license, the tail lights, and the license plate. Tail lights and illumination of rear and display of license plates. So if he pled to those, we would dismiss the OVI.
Yes, Your Honor, we'll plead to those 3 charges, definitely. So
Is that correct, Mr. Block?
it's 2. Well, I mean, he's just asking us to plead to the lights, the registration, and the license. Those 3 charges, yes.
And the OVI is dismissed.
And the OVI gets dismissed, no reckless.
Okay.
Yes, we'll definitely do that, Your Honor.
Anything you want to say, sir, before I finalize it?
No.
Do you have an explanation why you did not appear for?
Yes, actually, to be honest, I thought it was dismissed originally when I first came in here. I was told that's well within the margin of error, and I misunderstood and thought it was dismissed. Went on about my daily life, and then when I found out I had a warrant, I came and presented myself before the court.
All right. The A case is dismissed, that's the OVI. And I'm assuming you have a valid license now?
He does not.
I've been waiting to get this taken care of to go and get it reinstated.
Okay.
I've paid everything I need to pay for the reinstatement. I've just been waiting for this to be finalized. I didn't want to lose my license right after going and getting it reinstated.
Well, you probably have to retest now and everything's been so long.
I've already taken the permit test. I just haven't taken the road test.
Okay, on the B case, which was not having a valid license at that point, I'll impose a $200 fine.
And I did have valid insurance and everything at the time. I just didn't have it in the car.
The officer checked the box and you did have proof, so.
That's good.
So you don't have to show proof now. He said you had proof then, so.
Okay, I thought that was one of the charges I was pleading to.
No. Failure to display registration.
Okay, I did have the registration. It was in the glove box. The sticker just was not on the plate. I'd literally gotten it a few days before that.
It's still a failure to display, but it's okay.
Okay, I'll impose a $10 fine.
Yes, yes, Bob.
Then the other was tail light out or license plate light, I think. $10 fine on that. And do you need time to pay this or do you pay it today?
What's the total? I can pay some on it today, but I'll need at least a couple of weeks to pay the full
Okay, here's
balance.
what I'll do. I'll give you a final pay date of June 25th.
Okay.
So if you pay it by then, you're good. If you pay it after that, we will send it to the DMV and they'll suspend you for not paying it. Which means, you don't have a license now, but you won't be able to get one.
Okay. And what was the
suspension?
The total on the fines was $220, but there also will be court costs.
Be court costs and the signed counsel fee.
Yeah, so.
So So that's 165 plus whatever the fines were.
220 plus 165.
Yep.
And that's all I owe.
That's it. Yep, that should pay it all off. All right.
State of Ohio recall Sean Woods. Case number TRC. He's coming back. Case number TRC 23-811-8 through D.
So this is actually on a sentencing docket. He's at RRS. Mr. Steyer standing in. I guess Mr. McCown's taking over now.
Yeah, so Mr. McCown asked me to stand in this morning. I apologize for not hearing the case earlier. We were wrapped up in that issue with the translator, and it got very, I guess, difficult to hear what was going on. I apologize. My understanding was that this matter was basically worked out, but I'm also hearing that there may be an issue today.
Test positive for alcohol.
Right, that would be the issue I heard about, in case I was misinformed, I didn't want to say it. So my guess at this point would be that it would be best to allow Mr. McCown to handle this at this point with whatever further action the court wants. It sounds like he's still in services, so I would assume he would continue those services at any rate, and that maybe we can get a better test result when we're back here with Mr. McCown.
Let's come back in another month. We'll make it April the 19th.
Thank you.
For sentencing, 10 o'clock.
Thank you.
You're welcome.
Thank you, Your Honor.
State of Ohio versus Tony Walters. Case numbers CRA 23-466, CRB 23-467, A and B. Case number CRB 23-54.
All right, Ms. Walter is here. She missed the hearing March 1st. She didn't have an adequate reason for us. I put her in the back. I'll give you another chance. You got to come to court when you're ordered to. Your next hearing. And Mr. Tyler Smith is your attorney.
Yeah.
So I'll make it April 12th. And we'll notify Mr. Smith that's when she can be released. April 12th. I'm gonna write that down.
Thank you.
You're welcome. Okay, court's adjourned.
I know I don't go in. Like trances and just let places go. I mean, I was asking you a question.